Augusto Zimmermann is head of law at the Sheridan Institute of Higher Education in Perth and an adjunct professor of law at the University of Notre Dame, Australia, president of the Western Australian Legal Theory Association, editor-in-chief of the Western Australian Jurist Law Journal, and a former Law Reform Commissioner in Western Australia. That's quite some CV. It's important because he is recognised as a fierce advocate for free speech and the rule of law. Professor Zimmermann is the author and co-author of numerous books, including Fundamental Rights in the Age of COVID-19, as well as contributing to another book, Unchain Australia, and he also writes regularly on constitutional law and basic freedoms for The Spectator Australia and for Quadrant, among others. Professor Zimmermann, welcome back to Outsiders. How are you?
I'm very well. Thank you very much for the opportunity to be having the discussion with you.
Well, it's great to see you, Augusto. Let's kick off with Clive Palmer's. There are two things I want to cover this morning. One is, and in keeping it as in the lay, so it's accessible to the layperson, Clive Palmer's challenge to the West Australian Premier. I want to talk about that, the closing of borders, whether that's unconstitutional, and then we'll chat also about whether vaccine passports are unconstitutional or not. Tell us about Clive Palmer's challenge to the WA border closures. It failed the first time round. Can it succeed? What will happen next?
Well, he is appealing perhaps to the wrong provision. He's saying that Section 117 would be the relevant provision to be challenging these measures. And this particular section in the Constitution is referring to differential treatment between citizens on the grounds of residence. I believe that, unfortunately, when it comes to the government of Western Australia, they are equal opportunity providers of violation of fundamental rights. It's not that residents from other states will be discriminated against, but the decision made is that anybody who travels or visits New South Wales will be forced to take the vaccine. And that means that perhaps the relevant, the most appropriate provision should be Section 51(23)(a) of the Constitution, perhaps in combination with another provision that's quite important, which is a section dealing with this is basically provision 117 of the Constitution, saying that 92, by the way, of the border impediments, basically saying that citizens have the right to freedom of movement. And freedom of movement is extremely important because that's the reason as to why we established the federation in the first place, so that citizens could cross the borders without any impediment whatsoever.
So, Augusto, do you view vaccines, passports, therefore, as an impediment? So does the same basic logic apply that vaccine passports are an impediment? Tell us about that.
The point is not just that it is an impediment, because the Constitution also impliedly states that everybody should receive equal treatment before the law, and that's a decision made in 1992, saying that quite clearly, that the High Court stated that everyone should be treated equally before the law. But another thing you have to bear in mind is that this Section 51(23)(a) of the Constitution explicitly states that we should not be forced or coerced to receive medical or pharmaceutical treatment. If that is the case, then it is a form of coercion that is considered since 1949 in a very important decision of the High Court, the British Medical Association Commonwealth, that this sort of coercion is considered to be constitutionally invalid, as perhaps an implied right of the individual derived from the Constitution, because civil conscription means that you are being forced to take some sort of medical pharmaceutical treatment. That is considered to be utterly unconstitutional for more than 70 years in this country.
James.
So I want to ask you about this challenge to the WA border ban and what the implications of that are. Section 92 would seem to be very, very clear about the right to move freely throughout the country. Now, in the decision knocking it back, Kiefel and Keene said, well, there was no vaccine, there was no this, that, or the other thing in this special pandemic time. Are you concerned that Mark McGowan will challenge any attempt to open his border by saying, well, look, our hospitals are not capable now of managing this vaccine, so therefore we have to stay closed on public health grounds, therefore, vitiating Section 92 more? And are you concerned also that the precedent that this sets is one where the government stops being about protecting our liberties and our rights, which it should do in a constitutional democracy, and more about protecting our health, in which case it's more of a biomedical state, to use a philosopher's term, where all of our rights are vitiated by this one particular narrow lens of health?
Yes, this is all a very good arguments or positions that you have just stated. And what I have to say is that if the government is not competent enough to manage the hospitals in a proper manner, the individual citizens should not be punished and have their fundamental rights taken away from them. These measures are a violation of the spirit and the letter of this Constitution that was established as an instrument to limit the power of the state and guarantee that the citizen is the recipient of fundamental rights, inalienable rights, and freedoms. And I must say that Section 92 is very clear, saying that the border should be absolutely free. The word used by the drafter of the Constitution makes it very clear that there was a concern that in the future someone could interpret this in a way that perhaps is not in accordance with the intention of the drafter. That's why the term used is absolute, absolutely free. So that particular decision in Clive Palmer and the Commonwealth was very disappointing. Disappointing also because the Commonwealth was not able to intervene in favor of the Constitution. So that was a neglect on the part of the government, federal government, to have stood for what is right. And certainly, there is no way the High Court should have decided that the border should not be entirely open. You can say that as a result of an emergency power or something of this nature, given the fact that we have an alleged pandemic, then that the borders should be perhaps extraordinarily closed for such a reason. But you have to bear in mind as well that emergency powers, according to philosophers and legal theorists and jurists, including Hayek in this case, Friedrich Hayek, they always say to us and refer to the fact that in the past, emergency powers have been used as an instrument of oppression. And what was supposed to be temporary became permanent in the long term. So the tendency now is that this that's called to be a temporary measure will reverse itself in something to be more permanent. And then our rights and freedoms will be undermined forever in this country.
Augusto Zimmermann, Professor Augusto Zimmermann, thanks so much for coming on Outsiders. And Scott Morrison, pay attention. If you want to win the next election, open the borders, stick to the Constitution, do what should have been done all along. Tell the states that they cannot shut down our borders like this. We're taking a short break. Back in a tick with Ice Age Watch.